Good afternoon, everybody. It's the top of the hour. It's 1 o'clock, and so we want to get rolling here. I know everybody has got a lot going on these days, and so we want to make best use of your time, and we appreciate you joining us here this afternoon for our webinar. They gave us this very fancy breaking news initial slide, COVID-19 response team update. I learned earlier today that this is the 90th webinar that the Miller-Johnson team has put on since the start of the COVID crisis. And so we're glad you could join us this afternoon. Our topic, meetings, masks, and miscellaneous, what the Michigan Supreme Court's decision means for schools. I'm Kevin Sutton. I work out of the Detroit office of Miller-Johnson. Excited to be joined today by my partners, Bob Schindler, who's with me in Detroit, and Cathy Tracey, who works out of the Grand Rapids office. And glad you could join us. It's obviously been an interesting many months for all of us in the world of education. And here we thought we were going to have a nice, quiet first weekend of October. And then late Friday came the decision from our Supreme Court regarding Governor Whitmer's executive authority. And that nice, quiet weekend went right out the window. And we had to figure out how to move forward this week and beyond. And I know many districts, particularly in the Metro Detroit area, we're getting back to in-person learning this week. And so it added another layer of complication in what has already been several months of complication and confusion. But we're going to do our best here during the time we have this afternoon together to address some of the most pressing concerns and the questions that we've already gotten many times over the last 24 to 48 hours from you, and we'll try to address those. There's, of course, the questions tab in your control window. So if you have questions, you can put questions in the Q&A tab, and we'll do our best to respond to those throughout the course of the presentation this afternoon. So you get to hear from all three of us today, and I get the pleasure of leading off. And I will pause here very briefly. You know, attorneys love to throw disclaimer slides in that says, you know, for the next hour, I might be your lawyer, but I'm not your lawyer. But I think this slide is particularly pertinent today, particularly apropos, just because of where we're at. We have very rarely lived in an environment where the information was changing hour to hour, minute to minute. And that very much is where we're at right now, where information is changing minute to minute and hour to hour. And so what you're going to see over these next slides is consistent with what we knew at 12:30 today. By the time we get done, who knows? There could be even more guidance that's out there. So very important to check and double check as you move forward and you make decisions as a district and perhaps modify some things. So the disclaimer has particular importance today just because things are evolving and changing so darn quickly. In terms of our webinar today, what we're going to talk about are these topics, the effective date of the Supreme Court's ruling. We're going to address virtual board meetings and what you should be thinking about in terms of those. We're going to talk about safety protocols, masks, social distancing, etc. What does this mean for the school roadmap? And what about other authorities that are out there? Of course, we got Department DHS guidance last night, which I jokingly said amongst our group looked like there was a lot of cutting and pasting going on in Lansing yesterday. Read a lot like one of Governor Whitmer's prior executive orders, but some guidance from the Department of Health and Human Services that gives us a little bit more parameter on what we should expect going forward. So we're going to try to address all those topics, and we've tried to do this in a bit of a frequently asked question format to make the most sense of all the information that we have. We've got a little bit of a Wild West theme going on in the presentation today, and so you see the bucking bronco there, because it kind of feels like the Wild West at this point. What are the rules and who's making them? We sort of have that vibe, so you'll see that sort of permeate our presentation this afternoon. As we talked as a group yesterday in terms of trying to establish some guiding principles, you know, sort of what do we do immediately? And many of you reached out early in the day yesterday about boards that wanted to do stuff, maybe didn't want to do stuff, and how to respond. Our guidance at this point is let's stay the course for the short term. I think if we run out and we start doing a bunch of things, there's a real good chance that we're going to get additional guidance from departments, perhaps from our legislature or elsewhere, that might end up upsetting whatever you do in the short term. And so I think maybe taking a deep breath and seeing where we're at and what comes out over the course of the next 24, 48 hours is really going to tell the tale and might answer a lot of the questions that we have in the immediate aftermath of the Supreme Court's decision. Maybe thinking about if you really feel compelled to do something and you want to take some steps, there certainly are some areas where the restrictions were relaxed by executive orders. And if there are things that we wanted to have be more aggressive, certainly, as we're going to talk about, we have local control as school districts, and those are things that we can look at doing. But it's hard in this environment to say, let's take a deep breath, let's take a second to pause, let's look around and see how the playing field lays itself out. But I think that probably is wise guidance at this point, is to see what we get, particularly here over the next couple of days. So let's talk about some of the basics that are coming up and are some of the questions that we've heard a lot over the last couple of days, and give a baseline, which will sort of set a foundation for what Cathy and Bob will talk about subsequently on some more particular issues. When does the Supreme Court ruling take effect? There was a lot of dialogue about that in the immediate aftermath. Governor Whitmer suggested 21 days. There was a press release on Monday that said she was asking for 28 days. We have taken the interpretation that it takes effect immediately. And so this idea that there's a 21-day waiting period or a 28-day waiting period, we don't think holds really any water. And I think the governor would even begrudgingly admit that. She came out with a video late last night on her Twitter that seemed to acknowledge that these things, the Supreme Court decision is going to have immediate effect. And so that is the framework within which we are operating and giving guidance and counsel as if the Supreme Court decision took immediate effect. What does it do in terms of impacting the FFCRA or federal guidance pertaining to special education and FAPE? I'm tempted to say let's wait and see, but I think really we don't think it has any impact on these federal laws in terms of what's been articulated from an employment standpoint under FFCRA, in terms of the guidance that we've gotten under IDEA and Section 504. Those are obviously all federal statutes, and so the court's ruling is limited to an analysis of Michigan laws. On the issue of special education, certainly there's been a number of guidance documents over the last handful of months from the MDE about special education students, how best to support and contingency learning plans, and all that good stuff. At this moment in time, we have no reason to believe that that guidance is no longer valid. I saw we got a memo late last night from Dr. Rice, who referenced the DHS guidelines. I suspect that there will be more from MDE in the coming hours, but for now, on that front, we will continue to stay the course. Of course, if you have particular questions about special education compliance, certainly reach out. But for now, we will maintain the status quo on that front. One that we've gotten a lot of questions about in the last couple of days. We have a board meeting coming up. Can we still hold it virtually? Because of course, that's what everyone has been doing in our attempts to comply with the executive orders and model best behavior with respect to gatherings and whatnot. And the governor's executive orders had given us the ability under the OMA to hold these meetings virtually. So can we still hold it virtually? I think the short answer is no. We cannot, because the extensions that the governor had provided us under her executive orders are no longer there as a result of the Supreme Court's decision. In order to have a valid meeting under the Open Meetings Act, we are going to have a quorum of the board physically present. And so today, at this hour, at this point in time, doing things the way we have been doing them for the last several months is not going to work. Now, I would note, and I think I've got my dates right here, Governor Whitmer issued an order sometime around mid-April, which extended our ability to hold virtual meetings until mid-May. So we will assume that those meetings that happen in that window of time are still okay. We're still done with appropriate authority consistent with the Supreme Court's decision. Everything after that is a question that we're going to talk about here in a moment. But in terms of upcoming meetings, we're looking like we're going to have to hold them in person potentially. Whether a partially virtual meeting is permissible under the OMA is still an open legal question. And what we mean by that is, what if you just had the board present physically and everybody else was virtual? So in other words, you wouldn't have an audience necessarily. That's going to be a difficult legal question. There's some nuance to the Open Meetings Act, which suggests that maybe we need to have people present. Certainly, we don't think that would be advisable under the new DHS guidelines. So there's a bit of an open question. So because of this, because of the uncertainty about your next meeting, we are recommending that you postpone your monthly meeting if possible, at least for a week or so, until we can see what comes out. I think it's very likely that we will see some legislative action on this front that will tell us about virtual meetings and whether or not we can continue in that regard within the structures of the Open Meetings Act. And hopefully we get some guidance from the government here in the next couple of days. But if you have the ability to postpone your meetings, because right now you're going to have to do them in person, we think that would be advisable. If you can't postpone your meetings for some reason, would certainly recommend that you consult with legal counsel about the best way to pull off an in-person meeting, certainly obviously following DHS guidelines. But there's going to be a little bit of challenge with that, particularly because everyone has grown so accustomed to doing things virtually. So I want to say more information to come, and we hope there's more information to come that will provide some clarity. But if you can buy yourself a week or two before your next meeting, we think that would be advisable. What about this window of time? Are board actions that occurred during the prior virtual meetings still valid? So as I alluded to, the governor's executive order in mid-April extended the exception to the OMA to allow us to hold virtual meetings until mid-May. Assuming we interpret the Supreme Court's decision to mean that anything that she issued from an executive order standpoint after May 1 was not valid, didn't have the effect of law, she didn't have authority to do so, that suggests that we have potentially a number of meetings that maybe weren't held validly. Obviously, we were all operating under what we understood to be the rules, so on and so forth. But from mid-May until now, if we had virtual meetings, what about those decisions? What do we have to do with those decisions? Again, we expect that legislative action will be taken retroactively to validate board actions that were taken in good faith during the shutdown period. We think that we can certainly operate as if they were valid. This is not anything that anyone could have predicted. Certainly everybody was adhering to what they understood to be the governor's directives with respect to permissive use of virtual meetings under the Open Meetings Act. And so to now come back and say those actions weren't valid seems to be, would be an inappropriate conclusion. Again, we expect the legislature to act. The boards exercise local rule, and in many instances, we think that this is probably a situation where this is the ultimate exercise in local control until we start getting more guidance from centralized government at a state level, departments and otherwise. But we have the ability to exercise local rule as local school boards, and the actions that we took during this time were made consistent with that authority. We think this is probably only a procedural issue of whether or not, in light of the Supreme Court's decision, those meetings were valid. We believe they are. We believe that no additional action should be needed, but we're going to wait and see. And we did get some interesting questions in the last couple of days about things that were done. And obviously there were a number of things that got voted on in late May, in June, in July, and August in a virtual setting, including your return to school plans. And so we don't think that there's any reason for alarm here. We don't think there's any reason to be concerned, but we're going to have to wait a couple of days and see what unfolds. But we think this is ultimately going to be a procedural issue that if in fact, there is guidance or a suggestion that anything that happened May, June, July, August, September needs to be voted on again. There are procedural ways to address that in an upcoming validly held meeting. And so we don't want anybody to panic. It's not a throw the baby out with the bathwater type situation, but it's something that we are going to keep an eye on here for the next few days and see what additional guidance comes out of Lansing. So hold tight. And we will get some more information as we move forward. I see there are some questions about meetings in the chat. I will take care of that as I turn it over to my partner, Cathy Tracey. Cathy, masks and other safety measures.
Thanks, Kevin. So over the course of this pandemic, it seems that issues surrounding masks have been the ones that have triggered the most questions and debate. So I'm excited to be the one that gets to discuss them today. You know, and also, I don't know if any of you heard in the news, but, you know, after the Supreme Court's ruling on Friday, one of the attorneys who presented arguments, who I will emphasize was not associated with Miller Johnson in any way, said of the ruling that, quote, "This means burn your masks right now if you didn't already." That is not the advice that Miller Johnson is giving in any respect, but that does sort of beg the question, which you'll see in number 5, if Kevin will kindly advance the slide here. Can we still implement safety measures if we want to, like masks and social distancing and things like that? The answer to that is yes, we absolutely can. The revised school code provides school districts with broad general powers to provide for the safety and welfare of students at school and transit to and from school and at school-sponsored events. So I think it's clear that school boards have the authority to take those measures, you know, and as Kevin described earlier, I mean, boards in public and non-public schools already did that when you adopted your protocols on your return to school plan. So, you know, our answer to that is again, I mean, if you want to continue imposing those safety measures, you can continue to impose those safety measures. Which leads us to the next question of what if we don't want to impose all of those safety measures? Are we required to implement or continue to implement those safety measures that we've already taken? The answer to that is it depends on what measure we're talking about. As many of you have probably seen, yesterday, DHHS issued an emergency order that deals with largely with masks, sports, and limits on gatherings. I'm not going to get into all of the weeds on the order because we'd be here all day. But I'll go through some of the requirements that are specific to schools. The most significant, or a very significant one, is that all indoor gatherings must require individuals to wear face coverings. And there are some exceptions to that, which would include children who are younger than 5 years old do not have to wear face coverings. Note that that does not include children who are 5 years or older. Individuals who cannot tolerate who cannot medically tolerate face coverings are not required to wear them. One departure here from the most current guidance is that Governor Whitmer's most recent executive orders were requiring us to get medical documentation of a student's inability to wear masks, whereas under this DHHS order, a school or a business may take a person's word for it that they are medically intolerant. Another exception is for when someone is swimming. Another exception is when the individual needs to temporarily remove their mask for identification purposes. So, you know, if somebody's coming to pick up a kid from school and you don't recognize them, you could have them temporarily remove their face covering. Another exception would be for an individual who is communicating with someone who is deaf, blind, or hard of hearing, and the ability to see their mouth is essential to that communication. That individual would not have to wear a mask during that communication. Apart from those protocols, most of the safety protocols that are unrelated to masks, athletics, or social gatherings are not included in this most recent DHHS order. As we discussed earlier, as Kevin mentioned, you can still implement them on your own authority to provide for student health and safety, but they're not going to be required by the DHHS order. So, you know, some of your sanitation protocols and things like that aren't required, but certainly may still be enforced. So we got to, I kind of shot ahead on this one, but I suppose it bears repeating because there were at least 6 questions on this specific issue, which is, are masks required for students in grades K through 5? The answer is yes, according to the most recent DHHS order, except for in Region 6, masks are going to be required for all students who are 5 years of age and older, unless they are medically intolerant to wearing those masks. And the next question we have here is, how should a school handle it if we have a student or a staff member who is now refusing to wear a mask or follow some of our other safety protocols because they think that they have the right to refuse after this executive order? The answer to that, our position is you should impose the same consequences that you would have imposed before the Supreme Court issued its ruling on Governor Whitmer's executive orders. As we've discussed, I mean, it's starting to get a little repetitive, but I mean, the school does have the authority to implement its own policies. And, to the extent you have implemented a policy requiring masks or other safety protocols, it is absolutely within your authority and discretion to impose those requirements on both students and staff. And the next question, sports. So what does all of this mean for sports? Does my hockey player kid still have to wear a mask? Can the crowd stands at the next football game? The answer is yes and no. So yesterday's DHS order does have a section that deals specifically with organized sports. It basically establishes requirements for what institutions and associations need to do, and it sort of parses them into 2 categories. So it has portions that deal with things that organizers and venues must do, and then one section on what they should do. So first let's kind of talk about what they must do. What you must do under the DHHS order is ensure that athletes wear face coverings or consistently maintain 6 feet of social distance, except for in fleeting moments where they would be together. There is an exception for swimming. There is not an exception for athletes who can't medically tolerate a face covering. So that's not a change. That was MHSAA's rule already, but they specifically address that even in this order. So there is still no exception for athletes who can't tolerate a face covering. Another thing that organizers and venues must do is either ensure that the audience is limited to 2 athletes per guest, or for indoor events that are between 10 and 500 people, the event has to be limited to 20% seating capacity for venues that have fixed seating, and 20 persons per 1,000 square feet for venues without fixed seating. Masks are going to be required in all cases. In Region 6, there is a slightly broader attendance limit, but everywhere else, including Region 8, which used to be with Region 6, it's going to be 20% and 20 persons per 1,000 square feet. For outdoor events, up to 100 persons are going to be permitted. Masks are going to be required. For events with between 100 and 1,000, with a venue that has fixed seating, attendance is limited to 30% capacity. For venues without fixed seating, attendance is going to be limited to 30 persons per 1,000 square feet. And again, masks are going to be required for all of that. Concessions are also going to be prohibited for indoor sporting events. With respect to the shoulds, in this new order,
I think her phone got disconnected.
Uh-oh. Well, that's no good. I knew the 90th one was going to be the notable one. I think Cathy was winding down here on talking about sports and what to expect. And the important part is that she addressed the musts. And certainly, I think looking at the DHHS order and understanding what those expectations are, as I said at the outset, I think there was a lot of cutting and pasting going on yesterday in Lansing. It looks very similar to what we expected previously. She alluded to our hockey players, certain governing bodies I think we're going to wait to hear from, and I would expect we're going to hear from them over the next day or so. MHSAA certainly for our high school athletes, and some of the other governing bodies, MAHA for hockey and others, I think will weigh in on these topics as well. And that's as much time as I can buy for Cathy to try to hop back onto the call. With that, I think I'll move then to the next slide and note that we do expect, as we've sort of alluded to, a flood of directives, orders, and laws to follow the court ruling. Again, I think we should stay the course. Premature action before the dust is settled creates the risk of being forced to undo school district decisions that are made now. And I'm seeing a number of questions about taking a deep breath and holding off, implementing the K-5 aspect on the face mask. What about this open meetings thing? How are we going to create a virtual option for the public? These are problematic issues. There's no doubt about it. And I don't know that there's necessarily any clean answers for any of them, other than we kind of just have to wait and see. And I will tell you, if that strikes as a grossly unsatisfying response for you, it's grossly unsatisfying for us to give such vague advice. But I think that's unfortunately where we're at. On the Open Meetings Act in particular, theoretically, yeah, sure, have the board in public and have everybody virtual. But I think that you might have a legal challenge there because of the public participation requirement. And that's why I say it's still an open legal question. We really need the legislature to step up on that issue in particular and try to address it. Cathy, are you back with us now?
I'm back. I have no idea what happened.
Well, those things only happen when you're in a webinar only. So we were just covering the note after question 9. I think you had gotten through the muss on sports, and you were going to talk about the should. So if you want to do that really quick, I think then we can move on.
Yep. Okay. So the should on sports is that there was some guidance in the DHHS order that organizers and venues should incorporate the DHHS interim guidance for contact-free sports that they issued on September 14th. That guidance was guidance that, among other things, said that we shouldn't be doing contact sports competitions. So the recommendation from DHHS is that we no longer do contact sports competitions. Now, again, that falls within the should category, so we're not required to adhere to that. And I haven't seen any word from MHSAA on whether they are going to incorporate that, but that is the recommendation from DHHS. So we'll keep our eye on that.
Perfect. And then, Cathy, while you were getting back on, we talked about this sort of aspect of it of it's hard, it's unsatisfying to say let's wait and see, but unfortunately we just got to kind of wait and see on some of this stuff. Yeah,
I mean, everyone's going to get tired of us saying stay the course, but I think that's the answer. The only other thing I was going to flag real quickly is we have gotten a lot of questions on the authority of DHHS to issue these emergency orders, and kind of goes with the whole stay the course advice. But the answer is currently DHHS does have the authority to prohibit gatherings, prohibit the gathering of people for any purpose in order to control a pandemic. They also have the authority to establish procedures to be followed during an epidemic to ensure the continuation of essential public health services and enforcement of health laws, which would include, flattening the curve and making sure that our emergency rooms, stay, in a manner where they can serve us. So whether the laws with respect to DHS authority are subject to any constitutional challenge similar to the way that the governor's executive order was, sort of remains to be seen. And I think that's something that law firms, including ours, will probably be looking at. But for now, as it stands, DHHS does seem to have the authority to issue this order. And with that, I will turn it over to Bob Schindler.
Thank you very much, Kathy. Before I get going on these assorted questions, there were a couple of questions that have been posed that I wanted to talk about directly. I was going to do them in the Q&A, but I thought it might be good to address them straight away. One is the question in terms of your preparedness plans. And the question came up of, hey, so should we be reconfirming this in a board meeting? And generally, right, the law says we have to do that monthly anyhow. But yes, I think in your next board meeting, reconfirming that plan would probably be a wise thing. Again, when you're going to have that and how, we need to work through the details on. And one point that came up again in the questions is there are some rules in terms of gatherings and whether you have a room big enough and limitations above and beyond the 10 people indoors and the like. So there is a possibility to hold meetings within those limitations. The hard part, of course, is, well, what if people come and it's beyond the limitations? How do you deal with that? And you have to think through those points in advance and have to really be prepared for that when the time comes. One other question that came up as well in the Q&A before I get to the slides that I want to address is, the question was any changes to requirement for remote work? And what I would say on that point is the DHHS order does not specifically have the same requirements that the executive orders had that said people shall work remotely unless so on and so forth. It has the gathering limitations, but it doesn't have all the same remote work requirements. So that is an important point. Again, it doesn't mean that people can't work remotely if possible, and that maybe we need to think about who's working remotely and whether they should be, but it doesn't have the same requirements in that regard. So with that, all right, first question, how does this impact the roadmap and agreements or decisions we made based on it? So one thing that's important to remember on this is, the roadmap was based on executive order, but the roadmap itself was guidance. And our opinion now is that it still is. So in that sense, Kevin, can you show the answer on this one there? School district agreements were authorized by law and passed by board action. So again, if it's okay for us to have followed the roadmap, and our orders that we create via a board are still valid, right? Because again, this is local control, as we've said numerous times now. And I think the roadmap's still a useful tool. It's still useful guidance that we should be looking at and using, even if it doesn't have that executive order backing it up. It's still effective guidance that was created with a lot of stakeholders, thinking through the problems involved. All right, next question. How will phases now be handled for the purposes of reopening? Well, if you have reviewed the DHHS order, you'll notice there was no talk of phases other than there was one reference to Area 6, I think it was, but otherwise it doesn't have the same phase language that the executive orders have gone through. So we're not 100% sure yet what they're going to do, if they're going to take the same tact with phases. They've taken a much more overall approach when it comes to these limitations. So we're going to have to continue to watch. I mean, I think now we're going to shift from watching for executive orders to watching for DHHS orders or legislative action, because at some point we are hopeful the legislature is going to get back in on this thing and give us some clarity on a lot of these points that we've been waiting for. Now that this is considered, these executive orders are considered unconstitutional. All right, question 12. We have buildings in 2 counties and the health departments are inconsistent with one another. So what do we do? It's a good question, and the answer is going to be really, our approach would be to be as conservative as you can rather than trying to be as aggressive as you can. So in other words, the best option is to consistently implement the most restrictive requirements between the two. You can always, the next possible option is to apply each department's requirements on the applicable buildings, but this can get confusing both for your staff, for your students, for your families, because if the standards are different, and they're gonna want to know why, how to do it, what to do in this building versus that building. What we don't recommend is that you go with the least restrictive requirements, because then obviously the one county health department is going to say you're in violation. It's better to be more conservative on this one in terms of your approach and your process. All right, Executive Order 2020-65 suspended the requirements for teacher evaluations last year. So what happened to those evaluations now? Well, the good part about that one is that issue, or that EO, was issued on April 30th. So the Supreme Court decision says that the governor didn't have authority to issue after April 30th. And so because that one was issued on April 30th, we're going with the notion that she had the authority to issue or renew that order when it comes to evaluations. And so we don't need to go back and try to retroactively do evaluations at this point. Now, obviously, April 30th wasn't the end of the school year. So there is kind of an open question out there relative to, well, okay, if it's issued on April 30th, but it's forward looking, what does that mean? And in that sense, the Supreme Court hasn't, their decision doesn't guide us in that way. It's really about the issue date, not about the prospective nature of the order. So even though the school year hadn't ended by April 30th, we're going to, until we get either further clarification from the Supreme Court or otherwise, we're working under the belief that order was valid, and as a result, compliance with that order, meaning we don't have to have strict compliance with Section 1249 of the school code, is valid for the 1920 school year. Again, too, this issue of sort of the prospective nature of some of these will maybe affect other orders as well. Again, this is one of those things, it's Supreme Court ruled late on Friday. We're still figuring some of it out. And that's one of those questions that's going to linger out there. But again, we're taking the position that as so long as it was issued by April 30th, it is an effective order.
So that was the Q&A that we had queued up for slide purposes, but there's certainly a number of questions that have been filtering into the chat or the Q&A that we've got here, and I'll be happy to quarterback if Bob and Kathy, you guys want to jump in on some of these. There's a few that relate to masks specifically, and sports. So Kathy, maybe I'll ask you to field those. There's one here that says, to be clear, we no longer need to require a waiver for masks. That was a question that came in.
So yeah, that is correct. So under the DHHS order, the schools are allowed to, they cannot assume that a person who comes in without a mask or a student who's not wearing a mask is medically intolerant, but they can take a parent's word for it. Or an individual.
I think, Kathy, to Kathy's point there, that's a may, right? So
right.
In other words, if you as a school district chose to say, no, we want to see documentation, there's nothing in the DHHS order that says that you can't. It gives you a may that you can take their word for it.
Yeah, that's exactly right.
All right. What if a school district doesn't require their students K-5 to wear a mask at all times? Interesting question, anonymous attendee.
Well, then that school district would be in violation of the DHHS order. The penalties would include, it's a misdemeanor penalty punishable by, I want to say, up to 2 months in prison and a $500 fine. There's also a civil fine penalty of up to $1,000. I think as a practical matter, I think, what are we talking about? Are we talking about giving your kindergarten students an outdoor 5-minute mask break? Or are you talking about, not having your K through 5 students wearing masks at any time? I think one is less likely to trigger any sort of enforcement action. The other very well might, particularly if you have a student who becomes ill or a staff member who becomes ill.
All right. There has been a request, Cathy, that you sort of repeat what you talked about on being able to medically tolerate a mask, medically tolerate masks. And so just if you could clarify that again about questioning parents or taking parents' word, if you could just cover that again. There's been a request for that.
Sure. So under the governor's earlier executive orders, she made it clear that if a student was medically intolerant to a mask, they didn't have to wear one, but there had to be some medical documentation to support that. The new order that was issued yesterday by DHHS does not include the requirement that we have medical documentation. So what they say actually goes back to, it's similar language to one of the governor's earlier executive orders, where she said you can't presume that an individual entering your building is medically intolerant to masks just because they're not wearing one, but you can accept a person's verbal notice to you that they're medically intolerant of wearing the mask if that's what they tell you. So in other words, you don't have to get a medical note from an individual saying they're medically intolerant if you don't want to. But again, back to Bob's point, but you may require that if you want to enforce the mask requirement and make sure that people who are not wearing masks truly are medically intolerant.
Bob, one here for you about changes to teacher evaluations for the current 2021 school year. Are there any?
There are none at this point that have been issued. So, I think at this point, we need to move forward with the idea that we're going to try and do evaluations pursuant to 1249.
Mm-hmm. Just when I thought we were getting past the mask questions, what about an employee who doesn't want to wear a mask?
Well, if we want the employee to wear a mask, we can still tell the employee that they need to wear a mask. The exception, of course, would be if the employee is medically intolerant to the mask, then there would be an exception under the DHS order for that. And arguably under the ADA, if they were trying to pose that as something that they needed a reasonable accommodation for.
Okay. Another mask question: can we still require a medical waiver for the 6th through 12th grade students, but take the word of a parent for the K through 5th grade students?
That's a good question. I don't see any legal reason why you could not. I think you may have some practical issues with that, particularly if you have, the same set of parents that might have a high school kid and an elementary school kid, and you'll take their word for it with respect to one but not the other. It doesn't seem entirely consistent. The only legal consideration I can think of whatsoever is that there are legal restrictions against age discrimination, but I don't think that would really qualify because you're not really discounting the parent's word based on the age of the parent, but on the age of the student. But that's an interesting question.
Yeah. Now a sports question here, and I don't know if I'm right. It's kind of maybe jumbled up here a little bit. It says, do you think sports that are contact to take place for basketball season? So I think what they're asking about is contact sports maybe that are indoors, contact sports that's indoors. Obviously most schools basketball season starts in November. We have thoughts on that at this point in time?
I think my thought is hopefully we'll have more guidance by basketball season.
Well, and I look, I mean, there's always been, irrespective of your feelings on how this has been handled at a government level, good, bad, or otherwise, there was always, I think, with respect to the football piece and this sort of two-way street of, well, you can do it, but we don't want you to do it. And I think that, Cathy talked about that earlier, that, there's the should. We shouldn't have contact sports, but we know MHSAA took that as, mom didn't say we couldn't have ice cream, so we can have ice cream. And so, I just think that to Bob's point is something that we need a little bit more guidance on. And November seems like it's 12 months away still, but hopefully we get some additional guidance. Another question here, the DHHS language references face covering. Is a face shield now an acceptable replacement for a mask now that we have the Supreme Court ruling?
Well,
don't everybody answer at once.
Yeah.
It doesn't define a face covering, I do not believe.
Yeah.
Right.
It does not.
So I guess then at that point, you're looking to see if there's any guidance that comes out at a county level, if there's any county health department guidance on that topic. And of course, we know that we weren't taking shields as being the same as coverings, but the DHHS order does not address it. So I see another question that just popped in. We have, because of this, teachers are asking if they can wear shields now instead of masks. And I think that would obviously go to the plan that you've put in place. And if your plan required masks, then I would keep masks. Cathy or Bob, any different thoughts on that?
No, I think that definitely falls in the stay the course category.
Question about temperature checks and requiring temperature checks. Can we still require temperature checks? Don't know why we couldn't if that was part of our return to learn plan.
I would agree.
Yeah, I agree with that. I mean, and that also comes from EEOC guidance, which hasn't changed. So I don't see why the Supreme Court ruling would have any impact on that whatsoever.
All right. We've got one that is right in my wheelhouse. If a district does not comply with a should in the emergency order, does this create liability to a potential district's governmental immunity defense and potentially create negligence or gross negligence situations for the district? Thank you for that question. That is one of those that I think is a very, very good question. And I think it's one that we sort of all just plowed through when MHSAA said, go for it and let's do it. I don't want to turn this into a law question, a legal question from like a law school class, but and I'm not saying you're not immune, don't do it, cancel sports, but I at least think that there is a question there about whether or not you would be potentially acting in a way that would create a negligence exception. Now, remember, the district's immunity under the Governmental Tort Liability Act is very, very broad, except for some enumerated exceptions. And so I don't know that running with sports would necessarily create an exception to the district's governmental immunity. And I suppose from a gross negligence standard, if the district is endorsing it and you're operating on guidance from MHSAA, it'd be pretty hard to say that a coach was acting it with conduct so reckless as to evidence a substantial disregard for whether an injury would occur. And so, it's probably an interesting legal question at the end of the day. Practically, I don't know that it should change the way that we're handling things and taking the guidance that we're taking from MHSAA with respect to holding our sports. But it certainly would make for an interesting bar exam question. There's no doubt about it. No doubt about it. Yeah. And there got a question here.
Private schools on the line too. So there are some private schools on the line too, I know, and that is going to be a closer question for them because they don't have the heightened protection from negligence lawsuits that public school districts do. Right.
Is the Michigan DHHS order, that's hard to say, DHHS order only in effect until the end of October? Will we have to revisit all of this in a month? Do we expect the legislature will step in to clarify before the end of October? Well, I'll answer the last question first. Do we expect? Yes. Though expecting legislative bodies to do anything on our time schedule is a fool's errand. We certainly hope that they will. And I think the DHHS order only had effectiveness until October 31. Is that correct, everybody?
Yes, that is
30.
correct.
Yeah, October 30th. Okay. All right.
I also am glad you're the only one stumbling over DHHS as well. Thank you.
Yeah, no, you're not
No.
alone, my friend.
I did it too.
Is there capacity for an outdoor sports event with fixed seating 30% only, or is the 1,000 person limit still the max?
I interpret it as the 1,000 person is the max.
Yeah, that was my interpretation as well. It was 1,000 with those requirements that it gives in there. I mean, I think those requirements are to go over 100, but the ultimate max is still 1,000.
Okay. Now, the DHHS order speaks mostly about masks and gathering limits. What about social distancing? Some of us have very limited class sizes to maintain 6 feet of distance.
As I read it, it doesn't talk about social distancing at all.
Yeah, you're correct. It doesn't speak to social distancing, just like it doesn't speak to sanitation protocols or a lot of the other things that seem to make good sense, but they're just not part of this order. And again, that doesn't mean it's not going to be part of another order or something, something maybe that might come out from MIOSHA or another administrative agency. It's just not in this order that we received yesterday.
And at this point, I guess, again, is social distancing as much as you can still the practical thing to do? Yes. But, under this order, to the point, if you can't have 6 feet away in a classroom, does that mean you can't do it? I think you still can't. You can at this point. And even in terms of a lot of the orders, some of that social distancing wasn't quite required the same way in a classroom before as well.
Yeah, I saw somebody on here comment 6 feet has always been a guideline, not a requirement, correct? And yeah, that's correct. I mean, if where my kids go to school, there is no ability for them to maintain 6 feet social distancing, and I don't think that's unusual. So that was always sort of a recommended protocol, even in the roadmap.
Yep. All right, I'm trying to cull through the list here for a couple more. We've got a couple more about. Here's one. Wasn't the preparedness plan under EO 142? The extended plan would need to be reconfirmed, correct?
Yeah,
that's a good question.
But if I remember correctly, again, maybe we can. I hadn't prepared for this question right now, but this
is like stump the lawyers.
Yeah, then the legislature also then create the statute that says we have to reconfirm our preparedness plan on a monthly basis. So therefore, it's also backed by legislation as well.
Okay.
I hear crickets. Is that?
We're going with it, Bob. We like it. We're going with it. Remember, we had that disclaimer slide at the beginning, so we're okay. We can do whatever we want. It's fine. I have one that I actually can't answer because I didn't attend the webinar yesterday. But it says over the Miller Johnson webinar yesterday, they shared that EOs 153, 160, and 161 are still active. Could you explain again why this is?
Oh, I can explain it. So, although it's not anymore, and this kind of goes to how things are changing very quickly. So, as of yesterday, there was a DHHS order, emergency order that basically adopted the executive orders, those executive orders. The new executive order that came out yesterday established these new guidelines and rescinded that earlier order. So you can ignore 153, 160, and 162 because that has been rescinded. This new order issued yesterday is what we have to refer to.
Okay, we've got a few more here on social distancing and masks in the classroom. If you can social distance apart in the classroom, does a K-5 student need to wear a mask? I think the answer is yes, because the DHHS executive order or emergency order says so. Kathy, am I right on that?
Yes, that's correct. There's no exception for mask wearing based on the ability to social distance.
Okay. All right. How are we doing on time? We got to take a couple more here. How will contact tracing take place if the standard 6 feet of social distancing is not a guideline? Maybe this is a health department question, but contact tracing is based on physical distancing standard of 6 feet. Well, I guess I don't know as a baseline assumption that contact tracing is necessarily only based on the idea of physical distancing or social distancing. I think it's exposure to someone with symptoms for a prolonged period of time. So I don't know. I would say that that's probably, you're right. It probably is a health department question and not one that we would necessarily have any insights on at this point in time, unless Kathy and Bob prove me wrong and tell me they have some thoughts on that.
Well, I mean, I think it kind of depends on, I think how it impacts the contact tracing is if you have students who are within 6 feet, for instance, in the classroom, if your chairs are 3 feet apart and they sit there for an hour together, then you're going to have to report to the healthcare department that all of the students surrounding an infected individual have had prolonged contact. So, I mean, I think it could implicate it in that way, but I think if you don't use 6 feet of social distancing in your classroom, you're going to have more kids quarantined.
Mm-hmm. So we have another series of questions about gathering limits now internally. So I'll just read a couple of them. Are school cafeterias used during the school day included in the gathering limits? Another question, can we take the band class inside again if we use the masks made with slits for playing? Then we've got one that says, if we don't make exceptions for classrooms as the executive orders did, are we then in violation if we have 20 students in a 900 square foot classroom, for example? And so a series of questions about stuff in the building under the DHHS gathering guidelines.
So I think first I'll cover maybe both the last one and sort of the first one, right? Which is the gathering limitations. There's an exception to the gathering limitations for students in a classroom setting or children in a daycare setting is how it's worded. So one, in terms of the limitation, it wouldn't apply in a classroom necessarily. Secondly, as far as cafeterias go, I believe, yes, it would, because that would not be a classroom setting. And so as a result, the gathering requirements, indoor gathering requirements, and how you get above 10 and the rules on that would have to be applied in a cafeteria setting. I'm trying to remember some of the other ones, Kevin, because there was a lot of them there. The
band class, sorry, yeah, that was what they call a compound question. I apologize.
Actually,
the band class. Can we take the band class inside again if we use masks? Apparently, they're playing outside right now.
Yeah, I think you can.
Well, yeah, you can, because that would still be a classroom setting.
Yeah.
Right. I have a teacher who indicates that the DHHS order has limited indoor gatherings to 10 people and the classroom exceeds that. So we're actually violating that order. Do we have thoughts? I think see prior response, correct?
Correct.
Yeah.
Yep.
Teacher is not, that's not right.
Yep. Should employees be wearing a mask in the front offices at all time or only when staff, students, and visitors come in? I would say they need to be acting in a manner that's consistent with your return to learn plan and what the expectations are that you have articulated for your employees and for all your staff members. I would think we'd want the front office people adhering to those things as well, to the best of their ability.
Yeah,
let's see here. Sorry, Kathy, go ahead.
I was just going to say, I mean, unless the staff fall into one of the exceptions for mask wearing, medical intolerance, or, they're probably not swimming, but, you're within 5 years old. Unless they fall into one of those exceptions that we discussed, then yes, they should be wearing masks according to the DHHS order.
Yeah.
Some towns right now, we may all feel like we're drowning, but that doesn't make for an exception.
I'll ask one more here in the last few minutes that we have. With the mask mandate for K-5 in place, are schools required to continue to keep them in cohorts when it applies to recess, lunch, etc.? Schools implemented this in order to not be required to wear masks when in the classroom. Interesting question.
There's nothing in the DHHS order that speaks to cohorts at all. So I think that falls into the category of, do you think that if we think that it was wise and, a productive health and safety measure to keep kids in cohorts, then I think it makes sense to continue doing so, but there's nothing in the order that would require you to continue doing so.
And there's nothing in there that would allow you to not have masks for them if, other than
right.
the other exceptions and the like, even if they were in cohorts.
Yeah, correct.
Okay, with that, I see we've reached the top of the 2 o'clock hour, and so I will sound the bell and thank everybody for joining us. We got to a lot of the questions, not all of them. What we'll do is we'll take everybody that submitted a question. It's been recorded. We'll put together an FAQ document. So look for additional guidance to come out, additional resources to come out from us here in the next day or so. If you don't presently follow our group on Twitter, you're going to want to do that. It's at MJEdlaw. At MJEdlaw is where we put all the latest and greatest breaking news and stuff, new resources, blog articles, FAQs, and I suspect that everyone in our group will be busy here over the next few days cultivating some content for that, and we'll try to address any of those questions that we didn't get to and put out a document, and we'll broadcast that through our Twitter at MJEdlaw. Be sure to join and follow us, and we'll get you all that stuff. Bob and Kathy, thank you very much. Always a pleasure. Appreciate everybody joining us. We know it's a crazy time. Hang in there. Be patient. Take care of yourselves. Take care of your families, and we'll get through it. We will get through it for certain. So with that, thank you so much. Have a great day.
Thank you.
So